Welcome. Today, in this session 2, we shall concentrate upon specific relief act. Let us begin with the prayer to the goddess of justice. Let the grace of the goddess of justice take us within her folds. We shall be preparing well. We shall be very honest to ourselves in our preparations. Our dedication for the cause will take us to the folds of the goddess of justice. In session 1, we have been concentrating upon the Partnership Act. Specific Relief Act is another domain. It is altogether of different values. The aim, objectives, and connected aspects of the Specific Relief Act are certainly different than that of the Partnership Act. The legislative domain of Partnership Act has been to regulate the partnerships, to regulate the relationship of partners as a partnership entity. From natural person, there has been a step ahead to enter the legal person's domain. Now here in Specific Relief Act, the aim is different, the objective is different. Let us read the text a bit aloud. Let us imbibe the vision and values of this act. Let us update our dictionary. Let us translate text of Specific Relief Act from English into Hindi and back from Hindi to English. Let us express in our language the basic terms, the conceptual terms, the technical terms of this act. This act is a very short act, but it is very, very critical domain, as this domain is restricting the situations in which specific reliefs can be granted by the courts. This enactment, in a way, is of such importance that one can take specific relief. Therefore, the litigations under Specific Relief Act are of different generic. The specific reliefs prayer stand restricted under this particular act. Therefore, we shall first of all be through its objective. The Specific Relief Act has the arrangements of sections in 3 parts: Part 1, Part 2, and Part 3. These 3 parts, again, are taking us an organization of as many as 8 chapters. Therefore, first of all, we have to be through the organization, the arrangement of the sections as parts, as chapters. Each split, each arrangement, each division is to be comprehended well, because it is the organization of the text which will help us be parallel with its objectives, aims, and its reach. Part 1 is about preliminary sections. There are 4 preliminary sections which are specifying designation, a short title, sentence, commencement. Then there are specific definitions and savings, as well as the specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws. See this clause, see this section, be parallel with this section, visit this section time and again, imbibe the value of this preliminary section 4. It provides specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws. See the clear demarcation. The reliefs are regarding enforcement of the individual civil rights and not for the penal laws. Part 2 is titled Specific Relief. Its chapter 1 is Recovering Possession of Property. The possession of property is most valuable right. Possession is 9 points of title, means 9 out of 10 points are of property linked with the possession of the property. Recovery of specific immovable property. Suit by person dispossessed of immovable property. Recovery of specific movable property. Liability of person in possession, not as owner, to deliver to persons entitled to immediate possession. See, it is not that this possession is to be restored back only to the title holders of the properties. Title to the property is not essential condition to get back the possession. Means possession as such is most valuable civil right of the individuals. If A is in possession and if A is dispossessed illegally, then the possession can be restored back. Specific relief of restoration of possession is permissible under this enactment. That being so, we have to be through these provisions to imbibe as that illegal dispossession, even of the illegal possession holder, is permissible if the suit cause is implemented within the given period of 6 months. The general suit for possession on the basis of title has a limitation period of as many as 12 years. However, illegal dispossession of illegal holder of the possession as well is the cause for the relief permissible to be granted under this act, provided the jurisdiction, the court stands invoked within the given limitation period of 6 months. One shall sit comfortably and one shall imbibe this legislative sanction for protection of illegal dispossessor, provided the cause is taken up within 6 months. If A has taken an illegal act and the owner is not chasing it within 6 months, then it is only the title holder who will be within his rights to have such a relief, and the limitation period for him is 12 years. One shall be through these provisions and then go to chapter 2, which is titled Specific Performance of Contracts. The chapter 1 is about specific relief of possession, and chapter 2 is regarding the specific performance of contracts. See, these provisions, as these are only in respect of the performance of the contracts. The relationships, the rights, other than those of the contracts, do not come within the domain of this chapter. The specific relief provisions of chapter 2 of part 2 of the Specific Relief Act are restricted, are confined, are meant for the specific performance of contracts only. Therefore, we at the initial stage as well shall be well cautious, shall be well aware as that if the relief is to be prayed, relief is to be expected under chapter 2, then the essential, the mandatory, the specific start with condition is that the prayer for specific relief that way is to be in connection with the contract only. So all the rights which will follow under a contract are subject matter of cause and prayer under this chapter. Therefore, the essential mandatory condition will be that there shall be a contract and the individual shall have rights under the contract, and in respect of those rights under the contract, that one will be having a cause and the court will be within its power, within its duty to grant these specific reliefs. The specific performance of contract as well is on the face of it making us cautious that all contracts as such are not specifically enforceable. There are certain specified clause of contracts in respect of which specific performance can be made a cause, can be subject of a prayer, and will be the power, jurisdiction, adjudicating authority to provide, to give, to reach at specific performance degree. Therefore, it is not only that right is to flow from the contract, but the right shall be such that it is of the nature and a domain which can be specifically performed. Therefore, the contracts have to be visited and have to be adjudicated whether it falls within the group of specifically performable contracts or not. if there is a contract, but it is not of the category and species and generic of specifically performable contracts, then no relief can be expected under this chapter. As in chapter 1, we have to be specific whether we are coming forward for restoration of possession under a title or without a title. Then, with respect to the first situation of prayer of restoration of possession, otherwise, then on the basis of a title, then the limitation is 6 months. Otherwise, under the title, the limitation period is 12 years. Likewise, here in chapter 2 as well, there is a specific categorization of the contracts. Firstly, relief under this act is only with respect to the rights flowing from the contracts. And further, the restriction is that the contract shall be of the nature of specific performable category. That being so, we shall be through these provisions, these legislative sections of this chapter, and it is the domain, it is the sanction, it is the specific provisions under whose restrictions, under these conditions only, that the relief of specific performance can be expected and can be had. Chapter 3 is a specific legislative sanction. It is for rectification of instruments. Word instrument is in a way a specific nature of a legal document. Now, it is here that third category of specific relief domain is being taken up. It is the rectification of the instruments, and the situation of section 26 is which provides for as to when instrument may be rectified. Now, the incorrectness, etc., with respect to the clauses of the instrument may be for various reasons, and the same also may be of very large number of situations. The rectification is highly technical domain, and this technical domain is of the test of section 26. All documents cannot be rectified. All instruments as well are not permitted to be rectified under the sanction and seal of the court. This rectification of instruments is of specific generic, and this generic is as is legislated here in section 26. The fourth class of specific reliefs are The nature of recessions of contracts. Fifth category is cancellation of instruments. Sixth category of declaratory decrees. The cancellation of instruments, recessions of contracts, rectification of instruments, in a way, are three different situations, but these three together make one class. The provisions of Chapter 6 are declaratory decrees. One may take note that it is this class of declarations, specific declarations, which are being availed over and above all other reliefs which are being invoked in the civil courts. The declaratory decrees or the course or the situation or the mode which is of most practical relief availing domain. Then one is to be through these provisions, one will be face to face with as to how we human beings are trapped in situations when our rights come under cloud, when there happens to be some misunderstandings and there may be wrong impressions, there may be illegal assumptions, there may be greed, there may be many other distortive approach to human relationship under which the titles of the properties come under cloud. To have removal of the cloud upon the title is a situation which has been dealt with, which has been provided an answer, and it is this answer for which we individuals are invoking the jurisdiction of the courts, and courts are vested, civil courts are vested with the duty, responsibility, and rights to reach at declaratory decrees. There is one other reason why this clause, this domain, this generic of specific reliefs are being invoked frequently, as that in respect of such declaratory suits, the court fees is the minimal. It is the court fee which as well is providing such wide domain of specific reliefs for the citizens. Part 3 is titled as preventive relief, and Chapter 7 is titled as injunctions generally. Like declaratory suits, the injunction suits or the another class of suits for which citizens invoke the jurisdiction of a civil court, and this in a way is the consciousness of the civil society which has a norm that whenever one feels to be there any illegal prejudice for one's civil rights, then one can invoke the jurisdiction of the court and to obtain injunction against other party. The perpetual injunctions is a specific clause of injunctions. The injunctions of the nature of perpetual injunctions are in a way a final declaration with respect to the vesting or otherwise of the rights in a particular individual. It in a way is full adjudication. It in a way is the final seal of the court with respect to the particular rights in particular individuals. Therefore, we shall be through these provisions. Let us imbibe these values. Let us be parallel with the legislative vision. Let us be parallel with the realistic needs of the powers of the courts to grant specific reliefs. This legislative domain deserves to be imbibed well. Let us be through the text of this enactment. Let us avail the opportunity to read a bit loud the values of these provisions deserve to be imbibed well. We can take it an exercise to update our dictionary to include all conceptual, technical, and other beautiful words of this text. We shall also develop the art of translation and retranslation. We shall also inculcate the values of expression. Let us evaluate ourselves as to the extent to which we are imbibing the art of drafting. Thank you very much.